already dealt with in the last lecture about the Act. Now, certain questions being asked by our members regarding the pendency with the cases filed under the old Act and the agreements executed under the old Act. What is the consequence as per the new Act? These are all the questions raised by our members. So, I am just passing the mic to Mr. Balaji. He will give the answers for all the questions. Thank you.
Good afternoon. Humble pronouns to Justice Subramanian, Justice Anand, Venkatesh, senior members, advocates and friends. As my learned friend was fondly called the owner of the MBA, I would only make us think it's not rent control anymore. Control has been removed. That is the essence of the new Act, which I will come to it a little later. Last time we spoke, it was on 14th December 2017 when the Act was enacted and came into force, but rules had not been framed and date of commencement had not been notified. But now, recently on 22nd February, rules have been framed. The date of commencement of the Act has also been notified. What has happened in the interim period is, between the 2017 Act and the 2019 date of commencement, certain amendments, substantial amendments have been made to the Act. So what we spoke in 2017 actually does not apply today in view of Act 39 of 2018, which has affected substantial amendments to the original enactment in 2017. Change, as I said, change has always been a problem in our country. Right from the bus conductor. People don't accept change very easily. Change is now from protection under law to respecting the contract or an agreement between the parties. That is the sum and substance, letter and spirit of the new Act. You respect the agreement between the parties, whatever it is. It may be reasonable, unreasonable, you respect the agreement between the parties. And the Act intends to regulate the mutual rights and responsibilities of either of the parties, and there is no more control exercised as under the original Act, 1960. There is a popular misconception even today. The news media items which are not, they only added to the confusion. Powers have not been given to the Deputy Collector. There is a three-tier system under the new Act. The Rent Authority, who has very limited powers, more of administrative powers I would say. He is in charge of registering the agreement, posting the agreement in the website and assigning a number. If there is a refusal on the part of the landlord to receive rents for 2 months consecutively, the tenant can approach the Rent Authority to deposit rents. Suppose there is a disconnection of amenities. Under the old Act, it was basic amenities, water, electricity and drainage. The scope of amenities has now been enhanced to include lifts, staircases, lights in passages and other amenities considering the modern passage of time. So if there is a disruption of amenity, both the landlord and the tenant, not only the tenant, the landlord also can approach for restoration of the amenity. Suppose he is occupying the first floor, there is a disruption of amenity, namely the lift. He can approach the Rent Authority and ask for restoration. That is a new development in the new Act. These are the basic powers as long as the Rent Authority is concerned. And if there is a dispute with regard to the quantum of rent, as per the tenancy agreement, it is limited, his powers to fix rent is limited to the tenancy agreement terms. So there may be an agreement, there may be a dispute with regard to the interpretation of the terms. What is the rent payable after 2 years? Or what is the rent payable after 3 years? What is the percentage? That decision can go before the Rent Authority. These are the very limited powers of the Rent Authority. Powers of eviction go to the Rent Court. Last time when we spoke, the original Act 2017 said not less than, should be a district judge, not less than the rank of district judge. Now that has been watered down and the new Act says a Rent Court can be a member of a judicial service. Any member of a judicial service. And there is a proviso which now says where there is already a Rent Court, such court can be designated as a Rent Court under the new Act. And I understand that existing rent controllers are going to be designated as the Rent Courts. So I had a talk with the Principal Secretary who has been responsible for framing of the rules. So I had a lot of clarifications and grey areas. So I checked up with him. He said there is a proposal to do that. The powers of the rent court are to evict tenants on the application of landlord. What are the grounds for eviction? Grounds for eviction are willful default, of course. Here comes the protection for a tenant. A tenant can commit default. Landlord has to issue a notice under section 1064 of the TP Act. Provisions are made applicable here. In spite of the default, in spite of the notice, a 1 month period, no default continues, landlord is entitled to eviction under section 21(2)(b). Suppose the default does not continue, tenant pays up the rent within 30 days. The eviction suit is liable to be dismissed. So that is the protection given to the tenant. So tenant is given an opportunity to make good the arrears of rent and charges whatever. And if he makes up the default, the eviction petition will be dismissed. But the catch is the tenant cannot continue this default again in the same year. If he repeats, he does not have the protection of the dismissal. So he will be exposed, he will be entitled to an order of eviction. Owner's occupation is continuing. Misuse of the property, the landlord acts of base, acts of nuisance, everything is covered under misuse of property. Subletting is there. Unauthorized subletting is still a ground for eviction. Non-user, which was under the old act, 4 months consecutive period, tenant's building is not used, is a ground for eviction, except in hill areas under the old act. That provision does not find a place here. And owner's occupation, of a marked difference between the old act and the new act is the old act requirement should be bona fide, and a person for whom the premises is sought, whether residential or non-residential, should not be in occupation of his own building. Here that requirement is lifted. The word bona fide is removed from the act. There is only one place in the entire act where the word bona fide is used, is section 14(2), where there is a bona fide dispute with regard to the title. Tenant can approach the rent authority to deposit. That is the only place where the term bona fide is used. We have been very accustomed to use of bona fide and willful in rent control proceedings all along. No more, we'll have to forget bona fides and willfulness. Default is default, requirement is requirement. As long as the landlord proves the requirement, he is entitled to an order of eviction. He did not prove that his requirement is bona fide. The acid test of bona fide is no longer on the landlord's shoulders. And similarly, other grounds are, in fact, the other marked differences in the new act is severance of tenancy. Splitting of tenancy is now permitted under the new act. This is a very marked difference from the old act. The landlord can agree to take portion of a premises from the tenant. Surrender of the portion of the premises is now permitted under the new act. Landlord is entitled to enter upon the tenanted property to put up an additional construction. If the tenant refuses, he can approach the rent court and ask permission of the rent court to put up an additional construction, if permissible, subject to municipal laws. So that is a marked difference which was not available. Once the property was let out to the tenant earlier, tenant had to be evicted for the tenant landlord to do anything in the property. Similarly, if there is a vacant space, suppose the property is 4 grounds, 2 grounds building is occupying, there is a vacant space of 2 grounds which landlord wants to exploit, it is open to him to approach the rent court if the tenant refuses to permit the landlord to enter into the premises. And as I said, it is now a suit, it is no more a petition. It's a summary suit, summary proceedings have gone, it is now a suit, court fee is payable as per the Court Fees Act. It's a landlord-tenant dispute which is 3% insofar as the city civil court is concerned. High Court we have this slab, the first 1 lakh is 4525 and remaining is 1%. So, and importantly, if you see, power of execution includes power to attach movable, immobile properties, recover monies due, which we have to see whether a landlord can also seek for recovery of arrears of rent in the suit, along with the application for recovery of possession. I presume the landlord is entitled to seek for arrears also, because execution proceedings permit the landlord, the court, to attach movable, immobile properties and for recover monies due from the other party. Another difference in section 10(3), which is the old act, owner's occupation. Once the property is obtained possession from the tenant, he is not entitled to let out for a period of 6 months. But here, if the landlord who obtains possession under owner's occupation ground wants to let out the property for a period of 3 years, within the period of 3 years, he must approach the rent court and get the permission. There is a fine of 25,000 rupees for violation. But these are the points where protection is sought to be given to the tenant. Okay, as I said, willful default, there is no more willful default. Default is sufficient for landlord to invoke the provisions of the Act. And coming to the agreement, this is what is bothering most of us. Section 4 mandates hereafter any tenancy between a landlord and a tenant should be in writing and should be registered with the rent authority under section 4. So what is the effect of non-registration? There is a provision which says, like I would probably compare it to probate, where unless a will is probated, it can't be received in evidence in court. Similarly, if you want to have the benefits of the Act, either the landlord or the tenant, they must have the agreement registered under section 4 of the rent authority. Otherwise, we are not entitled to the benefits of the new Act. Similarly, what is the rent payable? Rent payable is defined under section 8. As I already said in the beginning, the law respects the contract between the parties. So if there is already an agreement in place, subsisting agreement, the law requires you to register that agreement within 90 days from the date of commencement of the Act. That is from 22nd February 2019 up to 21st May. You will have, before 21st May, you will have to register existing agreements between the landlord and the tenant. Suppose it is an oral tenancy. That is also taken care of. 90 days within the from the commencement of the Act, within 90 days an agreement is to be entered into, and 90 days thereafter it should be registered with the rent authority. Suppose there is a dispute with regard to the rent. That gives a ground for eviction, which I would say probably chances of the landlords taking advantage of this. Refusal to enter into an agreement or failure to agree is a ground for eviction for both the landlord and tenant. Tenant can also say, I want to terminate the agreement, we have not reached an agreement, I want to walk out, give me back my advance. Landlord also can say, we have not reached an agreement, 21(2)(a), which seems to be a little loaded in favor of the landlord, 21(2)(a). Failure to enter into an agreement under section 4 is a ground for eviction. So this may work hardships to the tenant. But as long as there is an agreement in place, the terms are respected and tenant cannot be evicted during the period of the lease agreed upon. There are provisions for renewal also, where well in advance the landlord and tenant should approach the rent authority and inform whether they are going to continue or terminate. Similarly, tenant in cases of death of the tenant, the scope of successor has been increased now under the new Act. Originally it was only married daughters, unmarried daughters, now it is extended to daughters in general and widow of a predeceased son, apart from the usual son, spouse and either of the parents are also now coming within the definition of successors. This is insofar as the definition of tenant is concerned. Rent court, next step is rent tribunal. Rent tribunal, originally under the 2017, before the amendment, it said it should be not less than a judge of the High Court. Now they have said it should be a member of the higher judicial service. And existing tribunal, if any, can be notified. The great point is the rent control RERA is going to be designated as the appellate rent tribunal. So you may have to go to CMDA, ignore building, where RERA is there for appeals from rent courts. Appeals from rent authorities lie to the rent court. From rent court is the rent tribunal. Rent tribunal is headed by an appellate member who should be a member of a judicial service, higher judicial service. There are provisions, procedures for the rent authority and rent court are laid down. So it is more or less a self-contained court like the old Act. Summoning of witnesses, filing of proof of evidence, cross-examination, and procedure for inspection, all these are available. One marked omission is fair rent. There is no provision for fixation of fair rent under the new Act. Section 4 for fixation of fair rent under the old Act is no longer available to the landlord or the tenant because the sum and substance is you respect the agreement between the parties. Therefore, the contemplation of fixation of fair rent does not arise. If you want a higher rent, you agree or you vacate. So, fixation of fair rent is removed. As I think we should appreciate the 60-year-old law has been enforced for wartime enactment in 1960. Madras buildings was implemented from 1949, 1945 and 49. 1960 is replaced by the Tamil Nadu Buildings Lease and Rent Control Act. So it served the purpose at that time. But now with passage of time, with so many developments, availability of rental accommodation, the status of tenants increasing, their status sometimes exceed much better than landlord's position. They took undue advantage of the weakness of the landlords and exploit. We see proceedings are pending for 25-30 years. Again, time factor. The Act has very laudable objects. 90 days proceeding should be completed. Execution should be completed within 30 days. We will have to see how far it is going to be practically workable. If it does, I think definitely this Act would have served its purpose. And coming to the rules more or less, I won't say there is not much departure from what the Act, suppose it has to be subserving the Act. It defines the period, rate of interest. So here importantly now, if you want agreements, you can have interest for delayed payment, which you could not do under the old Act. The new Act respects, suppose the tenant does not pay January rent in February, he pays in March. You can charge him interest up to a rate of 8% per annum. Similarly, if the landlord refuses to refund the advance, it is again 8%. 8% subject to a maximum of 8%. Refund of advance, landlord will be liable to pay interest for refund of advance. Another thing is, there is differentiation between security deposit and advance in the new Act. The earlier Act encompassed everything under Section 7. Not more than 1 month's rent could be collected as advance or premium or whatever you call. But here there is a distinction made. Security deposit, maximum period of 3 months. You can collect maximum period of 3 months rent as security deposit, which is refundable across the tenant vacating. Besides that, the contract can stipulate any amount as advance. Can be 10 months, 6 months, 8 months, provided the landlord should refund the same across the tenant vacating, subject to, of course, deducting whatever is due. The finality of proceedings is also very important. The proceedings, the order of the rent court, subject to appeal by the tribunal, is made final. So there is no power of revision. So like what we used to do, the Land Reforms Tribunal, writ petition may lie, subject to admissibility. So finality is given in 2 stages, rent court and rent tribunal. In so far as eviction petitions are concerned, it is now only a 2-tier. It is decided by the rent court, appeal to the rent tribunal. Rent tribunal should decide within 120 days. If that is done, he is entitled to finality. And possession, EP proceedings are supposed to be concluded within 30 days. We will have to see how far again this works out. One thing which I found missing was the period of limitation. The Limitation Act has not been made applicable anywhere. Both the rent courts and the rent tribunals have been conferred with power to set aside ex parte orders. But what is the time limit within which the application should be filed is not specified. So landlord or tenant who allows the petition to be dismissed for default, can he knock at the doors of the court after 6 months or 8 months? That seems to be a grey area, which I in fact forwarded to the principal secretary also. He said he will come back on that.
33(2) does not apply?
Of the new Act.
That is appeal. He is talking about
Rent authority to rent court, setting aside. Limitation is available, 30 days for filing an appeal. Setting aside. Setting aside, it can't be open-ended, is my respectful submission. It has got power to set aside, but when should the tenant approach? He can't come at a indefinitely.
It's like a Consumer Protection Act.
Section 5 will be met.
No, if no special period is provided, then Limitation Act would apply.
The Act does not.
Unless the Act provides for a special period.
29.
That is, all the 29 Limitation Act would apply. Then Section 5 also would apply.
That is the registrar.
Yes, this I will clarify. Registration, there is a portal, tenancy.tn.gov.in. You go to the portal, create an ID for yourself, either the landlord or the tenant creates an ID for himself, you get registered. It is free of cost, no charge for that. Then there is a provision for application for tenancy. If you go to that page after registration, it will ask you for the details of the landlord, tenant, PAN number, Aadhaar number, what is the nature of tenancy, whether you are the owner or whether you are only a landlord, what is the authority you have from the owner, all those questions fill in the blanks. Format is pretty simple, it's not complicated. Once that is done, you are asked to upload the photographs of the landlord and tenant, the scanned agreement between the landlord and tenant. The fee of 100 rupees is charged for the registration under the new act. But it is independent of registration under the registration act. So if the agreement otherwise requires to be registered, and it also asks whether this agreement has been registered or not. So probably the rent authority may forward it to the registration authorities to avoid escape of stamp duty
You
for the
can
government.
have an agreement for any number of years in
It will be registered under the new act, but you will face a risk of the registering authorities impounding the law or calling upon you to register under the new act. I am also told, when I asked this question, he said there is a proposal to reduce the stamp duty for registration so that voluntary registrations, people will come forward voluntarily to register. In a way, it is good.
Balaji, you mentioned that pre-existing agreements also we have a...
Yes, within 90 days.
What about agreements to already lapsed and tenants are holding over?
You will have to enter into a fresh agreement under section 4.2.
And if they refuse, you evict them.
If they refuse, a ground for eviction.
This court
Same.
fee you were talking about,
Yes.
no? The court fee says 41
41.
Fee Act. But second clause 2 is quite clear. They say that the application for recovery of possession made to the rent court and memorandum of appeal presented before the rent tribunal shall be treated as a suit between the parties. But if you read clause 3 for a minute, the court fee
Applications.
on application filed before, both says application only. The earlier provision also says application. This also says application. So which does, what does...
I think 41 should...
So should
read as suit.
should 3 should override, and it is only like an interlocutory application and not 3% as you say. You read the clause 3 of
41. Provisions of the Tamil Nadu Court Fees and Suits Valuation Act shall apply in respect of applications or appeals to be presented before the rent court or rent tribunal or rent authority,
Yes.
as the case may be. Applications for recovery of possession made to rent court, memorandum of appeals presented before the rent tribunal shall be treated as suits. So that application is treated as a suit for the purpose of court fee, which means 3%, the landlord and tenant.
But if
The court fees on applications filed before the rent authority, that is only before the rent authority. That is treated as an interlocutory application, not before the rent court.
no, but if the earlier you see rent court and memorandum of appeal it says
Yes, before the rent tribunal.
tribunal. Okay.
There can be an appeal before the rent court also, from the rent authority's order.
Okay.
So,
it
before the rent authority, because his powers are very
Very
limited.
limited.
Therefore, they treat it as an application.
So
So you need not pay 3%, then you...
court fee.
Court fee.
Mr. Balaji, whether the execution court, rent authority, has got powers to give restitution of recovery of possession.
Not possession, only amenities. Only his powers are limited to...
Lawfully taken possession. Whether the rent
Rent
authority...
court can do it, not the rent authority. Rent court can do it, not the rent
Rent
authority.
court has a restitution powers.
And savings clause, as Mr. Kamalman was saying...
Suppose the rent court functions as a civil court and so far as execution is
Yes.
concerned, as in the case of the old act.
Yes.
Then no,
CPC
144.
is made applicable for execution proceedings. And the savings clause, which our owner wanted me to clarify in the beginning. Fondly called as the owner of MBA, so I'd like to maintain it. Existing proceedings will continue.
What about 11.4? Previously 11.4 was it? What about the...
No, I'll come to that. Existing proceedings will continue as if the new act has not come into force. Therefore, existing RCOPs, existing appeals, existing CRPs can be continued, but an exit option is given to the plaintiff, as in the landlord, to withdraw his suit or appeal, eviction petition or appeal within 180 days from the date of commencement of the act, and approach within 90 days thereafter, approach the new act and seek eviction. So if he feels there is more benefit for him under the new act, he can choose to withdraw his appeal or eviction petition, come under the new act. It is applied available only to the plaintiff, not to the defendant. So invariably it is the landlord who can take advantage of that. And as here section 11.4, there is a provision which says during the continuance of proceedings, tenant is bound to pay rent. And if there is a default, landlord can approach the rent court and ask for recovery of the entire arrears.
One question. There is, if you don't register, except for not being used in the court of evidence, the transaction is not invalid.
It is not invalid. So there is no penal provision as I see. There is no penal provision. That's why I said like probate.
So what is likely to happen?
Genuineness of will is not taken away. But you can't mark it in the court unless it is
I'm
probate.
asking this question is, lot of transactions will take place. If somebody is a tenant, maybe even for 5,000 rupees the people are tenant. The Act does not give any lower limit.
Yes, it applies to all tenancies.
But it's unlikely that most transactions are going to register. That problem will be there.
That's why they want to scale down the stamp duty and
It'll be the
If you don't
responsibility of
register,
the
you can't
landlord.
you won't avail the benefits. The landlord cannot seek eviction at all. He can't go under the old act as a repeal for new proceedings. So if he has to invoke the provisions of the new act, he has to register.
If there is going to be, if the say a tenant is going to be, is not going to cooperate, is there any provision by which I think you touched it. Is there any provision by which the landlord can compel him to come for there is a he doesn't want it's a oral lease and there is or tenant
The only ground for
eviction.
21
Straight
2A.
away, if he doesn't,
If he
you
does
issue a
not.
notice
Notice
with the
and-
draft agreement
Yes.
and he doesn't come, you'll have to go for eviction.
Go for it.
Can't compel him to be there and pay you.
Yes.
Can't compel him to be there and pay you.
You have read the act fully.
I have not read it, I heard it and I grasped it. So all credit to Balaji.
They've already registered a tenancy agreement. Do we have to re-register it?
Yes. Under this act, you have to register.
Okay. And then
To avail the benefits of the act, you will have it's only 100 rupees.
so because we've already
Otherwise, I said it's independent of the registration, it is required under the stamp and registration. This registration is different.
Then any renewal of registration, suppose 11 months, 11
Yes,
months,
it
11
provides,
months.
it provides. Before the period, you must approach the rent authority, there is a form under the rules, and say whether you are going to renew it or terminate. Accordingly, the rent authority has to upload the modification also. That is provided under the rules. Eviction has been ordered.
and EP has not been filed and appeal has not been preferred now.
Yes.
We can file EP.
That is your option. You can choose to go under the old act, execute and take possession.
Whether authorities are ready for this?
Designation, I am told, because it is in consultation with the High Court, forward proposal has been already sent to the High Court, and since Honorable Chief Justice was not in town last week, she was sitting in Madurai, this week I am told designations will happen. So if even today there is a lacuna, old act is repealed, the new RCOP cannot be filed, you can't approach the authority under the new act because you don't know who is the new authority or who is the court. There is a lacuna for the last 15-20 days which I am told will be addressed.
Whether it goes to the original authority or the appellate authority.
Appellate authority.
No.
We don't know.
No. Under RERA,
There are two.
one is the appellate authority, one is the original.
We have to see who is going to be designated. Higher judicial officer, no?
has to be on the
So since finality is also start to be given at that stage, I think they would probably think of
Will that be only one for the whole of Tamil Nadu?
one.
One appellate authority for the whole of Tamil Nadu? That will be a problem.
No,
That will be a
it
problem.
says existing appellate authorities can also be notified.
Ah, yes, can be notified.
So, existing uncontrolled appellate authorities can be notified. Maybe for Madras, he will be
No,
one.
there are probably district wise they may appoint other appellate authorities.
The authorities are prepared for these changes? Authorities.
That you ask the secretary of government. Why are you asking it?
Thank you.
I request honorable judges, present will follow through. All the three, please join, all the three judges. Please.
Yes.
You are the honors. Yes, you do the honors.
All the three. I request all the three.
Thank you.
Mr. Thiruvenuraman propose vote of thanks.
Balaji, such a large crowd here, and outside, inside also the manager room, and the other side also, the listening with rapt attention would speak volume about your quality of speech. Anyhow, I request you to give such more speech because this is a new emerging field, so everybody will have a lot of doubts. So I just request you to very often come and interact with the people so that people get enlightened and very useful to our members. Thank you so much, everybody.
In court. Rent court.
Rent court. Has he the power to sell the property to recover the money?
Yes, attachment and sale.
Has he the power to sell the property attached to recover the money?
I think sale is also given. Yes, attachment and sale. Execution, attachment and sale.
Thank you.
Thanks, sir. Thank you.
We'll have part 3.